Have you ever signed a contract and wondered if all those terms and conditions would really hold up if a disagreement arose? It is a common concern, especially when dealing with important business agreements. An arbitration clause, which is a common part of many contracts, can become unenforceable primarily if it is deemed unconscionable, violates public policy, or was procured through fraud or duress. Essentially, courts prioritize fairness and an individual's right to seek remedies. The core reason behind unenforceability often stems from the legal doctrine of unconscionability. This means a clause is so one-sided or oppressive that it shocks the conscience of the court. Unconscionability generally has two components: procedural unconscionability, which relates to how the clause was included in the contract, and substantive unconscionability, which refers to the unfairness of the terms themselves. For example, if a clause is hidden in fine print, uses overly complex legal jargon that prevents understanding, or is part of a take-it or leave-it contract with no opportunity for negotiation, it might be deemed procedurally unconscionable. On the other hand, if a clause imposes excessive arbitration fees, severely limits available remedies, or dictates an extremely inconvenient forum for one party, it could be substantively unconscionable. To help ensure an arbitration clause remains enforceable, businesses should strive for clarity and fairness in their drafting. This includes using plain language, making sure the clause is conspicuous and easy to find within the document, and offering reasonable terms that apply equitably to both parties. Avoiding terms that could be seen as unduly burdensome or that strip a party of fundamental rights, such as limiting their ability to recover damages for a legitimate wrong, is also crucial. When in doubt, seeking legal counsel to review dispute resolution provisions can prevent future headaches. Understanding the concept of mutuality of obligation is key here. Courts generally expect that if one party agrees to arbitrate, the other party should also be bound by similar obligations. A clause that only allows one side to compel arbitration while reserving the other's right to sue in court often lacks this crucial mutuality and can be challenged. This principle reinforces the idea that arbitration should offer a fair and accessible path to dispute resolution, rather than serving as a tool to unfairly disadvantage one party. Ultimately, an enforceable arbitration clause is one that is clearly understood, fairly presented, and offers a balanced approach to resolving disputes. By designing clauses that uphold these principles, businesses can create reliable mechanisms for conflict resolution, saving time and resources while maintaining positive relationships.